Welcome to Crisis in Perception, where we examine the systems shaping our world.
Today, we are looking at perhaps the most misunderstood system in American life. We are looking strictly at the Supreme Court, but, and I need to be very, very clear about this right up top, we are not looking at the political version of the court that you see on cable news.
Right.
We aren't talking about red robes versus blue robes or, who got appointed by which president to own the libs or save the conservatives.
Bro, none of that. We are stripping away the specific cases, the headlines that get everyone screaming on Twitter, and we are going to look at the underlying machinery.
Yes.
We're doing a systems-level analysis of constitutional interpretation itself.
Specifically, based on the work of legal scholar William C. Heffernan, we are going to map the incentive architecture of the court.
The incentive architecture. I like that phrase.
It's perfect, isn't it? It forces you to think about it like an engineer. We're going to look at how the Constitution was actually designed not as a static rule book, but as a mechanism for generating new unenumerated rights over time.
This is the part of the research that honestly blew my mind.
Yeah.
We tend to think of the Constitution as this stone tablet, right? Like, it's in there or it's not. If it's not in the text, it doesn't exist.
Yeah.
But the source material argues that the not in there part is actually a feature, not a bug.
It's the central feature.
And it's a specific system called developmental supplementation.
Exactly. And the mission for this deep dive is to understand that mechanism. How does the court navigate the tension between what is written on the page, the need for democratic consent, and moral standards that shift wildly over centuries?
Huge challenge.
It is. And to understand that, we have to stop looking at the decisions as isolated moral judgments. Did the court do the right thing? And start seeing them as outputs of a very specific, very old algorithm.
Okay, so let's unpack this. If we want to understand the code, we have to go back to the original programmers.
Back to the founding.
We have to go back to the founding. And Heffernan draws this crucial distinction right out of the gate. The difference between a plan as scheme and a plan as draft.
This is the foundational concept. I mean, if you don't get this, you don't get the rest of the argument. It's that important.
So let's break it down. A draft, and that's spelled D-R-A-U-G-H-T for everyone listening.
Right. Not the beer. It's an old term for a comprehensive code. Think of a modern tax code or a technical manual for a Boeing 747.
Okay.
It lists every single contingency. If a wire breaks, you do X. If your income is Y, you pay Z. It is exhaustive. If it's not in the manual, you generally can't do it.
Right. It's a closed loop. It's a complete set of instructions. It assumes the writers knew everything that could possibly happen.
Precisely. Which is, impossible. But the founders, particularly James Madison, they knew they weren't writing a draft. They were writing a scheme.
And a scheme is different.
Totally different. A scheme is an outline. It's a framework. It relies on what Heffernan calls incomplete textual specification.
Which sounds like fancy lawyer talk for we left it vague on purpose.
It is, but the why is fascinating. It wasn't laziness. Madison realized that if they tried to recount every minutia of government power or every individual right, they would fail. They'd never finish, for one.
And they get it wrong.
They'd get it wrong immediately. They couldn't predict the future. They didn't know about the internet or airplanes or wiretaps. So the indefiniteness, it creates an incentive structure for future actors, legislators, presidents, and eventually judges to fill in the gaps.
So the vagueness is an invitation. It's a space left blank for future generations to write in.
A very deliberate one.
But that sounds dangerous, doesn't it? I mean, if it's just a blank space, what stops a judge from just writing in whatever they want? The Constitution says I get a free pony.
And that right there, that is the counter-majoritarian difficulty. That's the central tension of American law. If 9 unelected people in robes just fill in the blanks with their own personal preferences, the system loses legitimacy.
It's not a democracy at that point.
It's no longer a democracy. It's a judicial oligarchy. So the system needs a constraint. It needs a validation mechanism. And this is where we get to what the source material calls the Madisonian framework.
And this isn't just theory. This isn't just Heffernan looking back and imposing a structure. We can actually see Madison himself struggling with this in real time, right?
We absolutely can.
The sources highlight his own evolution on this.
Yes, and it's remarkable. If you look at Madison in 1791 versus Madison in 1816, you see 2 different operating systems. In 1791, Madison is what we would call a strict constructionist.
The first version of Madison.
Madison 1.0. He argues furiously against the creation of a national bank.
And his reasoning was?
Simple. The text doesn't explicitly say Congress can make a bank. He says it's not in the draft. He is looking for a specific permission slip in the text, and he can't find it. For him, at that time, that's the end of the argument.
But then time passes.
About 25 years. The nation runs a bank anyway. The sky doesn't fall.
Right.
The economy comes to rely on it. It becomes integrated into the daily life of the republic. By 1816, Madison is president, and he changes his mind. He signs the bill for the second bank of the United States.
So what changed? It wasn't the text.
Why? Did the text change? No. The ink was exactly the same.
The consensus changed. The reality on the ground changed.
Exactly. Madison realized that the meaning of the Constitution isn't just in the ink. It's in what he and others at the time called liquidation.
Liquidation. That's a word we really need to flag, because in modern business, it means selling off your assets and closing the store.
Right. You have to forget the modern definition completely. In the 18th century sense, to liquidate meant to clarify or to settle.
Like liquidating a debt.
Exactly. You settle it. You make it clear. Madison argued that post-ratification discussions, legislative acts, and court decisions would liquidate the meaning of the text over time. It's a feedback loop. Practice clarifies the principle.
So let's break down the algorithm that Heffernan identifies from Madison's writings.
Yeah.
It's essentially a three-step process for legitimizing a new right that isn't explicitly in the text. This is the machine code.
This is the core of it. Step 1. No direct contradiction.
Okay.
You can't invent a right that explicitly violates a command in the text. You can't say, I have a right to be president at age 20 when the text explicitly says you have to be 35. The text is still the anchor. You can't just ignore it.
Simple enough. You can't break the hard rules. What's step 2?
Step 2. Consistency with the overall design. The new right or the new power, it has to vibe with the rest of the furniture.
I like that analogy.
It has to fit the scheme of liberty that the document establishes. It has to make sense within the logic of the system. It can't be some random out-of-place idea. It has to feel like it belongs there, even if it wasn't written down.
And step 3, which seems like the most important one for solving that judge's dictator problem we mentioned.
It is the crucial step. Step 3, validation through liquidation.
There it is again.
There must be a post-founding supermajority consensus. This is the check on the judges. They aren't supposed to invent rights out of thin air. They're supposed to recognize rights that the nation has already accepted in practice over a long period of time.
That is a huge distinction, a game-changing distinction.
That is.
It resolves that counter-majoritarian difficulty.
Yeah.
The judge isn't saying, I, a single unelected person, think this is moral. The judge is saying, the nation has acted as if this is a right for 50 years. Through its laws and customs, we're just formalizing it now.
Precisely. It anchors the decision in national history and settled practice rather than judicial whim. It turns the court into a lagging indicator of social consensus rather than a leading edge of radical change.
So the court validates what society has already, for the most part, decided is true.
And that's the theory of the system. That's how it's supposed to maintain its legitimacy.
Okay, so that's the architecture. That's the machine. Now, let's see what this machine actually built. Because the primary output we are interested in today, and the focus of Heffernan's analysis, is the right to privacy.
And privacy is the ultimate afterthought. It's the perfect case study for this system. The word privacy does not appear in the Constitution.
Not once. Not once. And yet, if you ask the average person on the street, you, listening right now, what your most cherished constitutional rights are, I guarantee you privacy is probably in the top 3. You assume it's there.
Absolutely. So how did we get from not in the text to fundamental right? We have to map the genealogy, and this takes us back to the 18th century. Phase 1, property as privacy.
This is where we have to get into the headspace of a guy like Madison or Jefferson.
Right.
They have to strip away our modern ideas about, feelings and data.
Yes.
When they thought about being let alone, they weren't thinking about abstract feelings or digital information. They were thinking about land.
Materialism. It was a very tactile legal system. In the 18th century, privacy wasn't a standalone concept. It was a subfunction of property.
A feature of property.
Exactly. You didn't have a right to privacy. You had a right to exclude people from your physical space.
Yeah.
If I own the land, I can build a fence. If I build a fence, I have privacy. The privacy is a consequence of the property right.
So the mechanism for privacy was trespass. The legal tool was the law of trespass.
Correct. Look at the Fourth Amendment. It protects persons, houses, papers, and effects.
All physical things.
Those are things. Physical things. If the government wanted to invade your privacy, they had to physically break down your door or grab your papers. The law stopped at the property line. It was a very simple physical concept.
But Madison, being the systems thinker he was, he saw the edge of this, didn't he? Heffernan highlights that 1792 essay of his.
Yes, his essay simply titled Property. It's a fascinating piece. Madison argues for what he calls a larger and juster meaning of property. He says, property isn't just your land and your merchandise. He says a man has a property in his safety and liberty of person. He has a property in his opinions and the free communication of them.
He's stretching the definition. He's trying to make the container of property hold more than just physical stuff. He wants it to cover the internal life of the human being.
He does, but notice he's still using the language of ownership. That's the key constraint of Phase 1. You own your opinions like you own your farm.
I see.
It's an exclusionary practice. I keep you out of my head just like I keep you out of my barn. It's defensive. It's about building walls.
So that's the baseline. Privacy is physical, defensive, and exclusionary. And it's tied directly to the law of property.
That's the starting point.
But then we hit the 19th century, Phase 2, and the vibe shifts. The economy changes, society changes, and suddenly property isn't enough to describe who we are.
Enter Ralph Waldo Emerson.
The transcendentalist shock.
This is a massive system shock to American thought, a cultural earthquake. Before this, the self was defined largely by its external relations. You were a father, a citizen, a property owner.
Your role in the community.
Exactly. Emerson comes along and introduces self-reliance. He introduces the idea of expressive individualism, the idea that the most important project you have is building your own unique soul.
This is the shift from material acquisition to identity. The focus turns inward.
Exactly. The goal of the American system, in this new cultural view, shifts. It's no longer just about protecting your stuff, it's about protecting your development, your ability to become a unique individual.
And Emerson has that incredible line.
He argues that the private life of one man is a more illustrious monarchy than any kingdom. He elevates the inner world to a sacred space.
But Emerson isn't a judge. He's a philosopher. He's writing essays, not laws. How does this fluffy, transcendentalist idea get into the hard concrete of the Supreme Court?
It takes time. Rumor liquidation. It's not instantaneous.
Right. It takes generations.
It takes generations for a social norm to become a legal reality. The ideas of Emerson and the transcendentalists, they percolate through the 19th century. You start seeing terms like identity formation and presentation of the self in popular and intellectual discourse terms that didn't exist in 1787. The culture acts on these ideas for decades before the law even notices.
The society starts to believe it first.
Yes, and the law, being a lagging indicator, eventually has to catch up.
And this brings us to Phase 3, the late 19th century, the aha moment where the legal system finally catches up to Emerson. And the key players here are Justice Bradley and, of course, famously, Louis Brandeis.
This is the pivot point. In 1886, in a case called Boyd v. United States, Justice Bradley drops a hint. It's just a seed, but it's there. He says the Constitution protects the privacies of life.
Not just property, privacies of life.
Plural. He's moving away from just the hardware of the house to the software of the life lived inside it. It's a subtle but profound shift in language.
But Brandeis is the one who really weaponizes this. He turns it into a full-blown legal doctrine.
Louis Brandeis, yes. In his dissent in Olmsted, this is the 1920s now, he performs a brilliant act of synthesis. He takes the Declaration of Independence, the pursuit of happiness, and he smashes it together with the Fourth Amendment's protection against unreasonable searches.
This is the famous right to be let alone.
Yes, that's his phrase. And it's so powerful. Brandeis argues that the makers of the Constitution undertook to protect Americans not just in their property, but in their beliefs, their thoughts, their emotions, and their sensations.
Emotions and sensations. That is a quantum leap from houses and papers.
It is a radical expansion. He did it. He detached privacy from property. He made it a standalone right. He argued that the government shouldn't just be stopped from breaking your door. They should be stopped from intruding on your mind.
And the context here is Critical Olmsted was a wiretapping case.
Right.
The government didn't break down a door.
Yeah.
They didn't trespass. They tapped the phone lines outside the house.
On the street. Public property.
Under the old property system, that's not a violation. No trespass, no foul.
Exactly. And Brandeis saw this. He saw that the old system failed because technology had outpaced it. The wires were on the street. If privacy is only property, you have no privacy on a telephone.
Liberty would die.
He realized that if we stuck to the draft, the literal text from the 18th century liberty would die by 1,000 cuts of copper wire. So he applied the scheme. He used the general design of liberty to generate a new protection for a new era.
So this sets the stage for the modern system. We move into the mid-20th century. The machinery of developmental supplementation that Madison envisioned really kicks into high gear, and we get cases like Griswold and Bowling.
And this is where we need to be very careful, because usually when people talk about Griswold, which famously legalized contraception for married couples, they get bogged down in the penumbra. They make jokes about shadows and emanations.
Right, the emanations and penumbras from Justice Douglas's opinion. It sounds mystical. It sounds like the judges were holding a seance to find the right.
It sounds like they made it up. But if you look at the incentive architecture, if you use the Madisonian framework, Griswold isn't an anomaly. It's what Heffernan calls a resulting right.
Okay, define that. What is a resulting right?
A resulting right is a homeless right.
A homeless right.
It doesn't fit neatly into one specific clause, one amendment, but it results from the total scheme of the Constitution. And the best example of this, the one that proves this isn't just liberal activism, is a case called Bowling v. Sharp.
I love this example because almost nobody talks about it, but it's foundational to understanding this whole process.
Absolutely foundational. So 1954. Same day, the court decides Brown v. Board of Education.
Right.
Brown says states can't segregate schools because of the 14th Amendment's Equal Protection Clause. Fine. But Bowling involved the District of Columbia. D.C. isn't a state. The 14th Amendment explicitly applies to states. It doesn't apply to the federal government.
So technically, textually, the feds could segregate D.C. schools. The Constitution didn't forbid it.
Textually, yes. The draft had a hole in it, a big one. But the court looked at the scheme. They said it would be unthinkable. It would violate the entire design of American liberty to impose a lower standard of equality on the federal government than on the states.
That would be absurd.
Utterly absurd. So they found an equal protection requirement inside the Fifth Amendment's Due Process Clause.
They reverse engineered it. They said, the system requires this right to exist for the whole thing to make sense, so we will find a place for it to live.
They did. Bowling is a quintessential resulting right. It's an afterthought. The founders didn't put it there.
Fine.
But the system demanded it exist to maintain legitimacy. Heffernan's point is that if you accept Bowling, and everyone does, nobody is arguing for segregated D.C. schools, then you have accepted the mechanism of developmental supplementation.
You've accepted the premise.
You've accepted that the court can and must recognize rights that aren't explicitly in the text to make the system coherent.
So when Griswold comes along a decade later and says, you have a right to privacy in your marriage, it's using the exact same logic as Bowling.
The exact same.
It's saying, look at the First, Third, Fourth, Fifth, Ninth Amendments. The entire scheme of liberty implies this private space, this marital bedroom, is protected, even if the text doesn't list it.
Precisely. And that's why isolating Roe or Griswold as some unique form of judicial activism while accepting Bowling creates a logical inconsistency. They are all outputs of the same algorithm, the Madisonian framework in action.
But now we run into a new problem, a new evolution. We've moved from property to identity. We've established these homeless rights. But now the environment is changing again. We are dealing with the technological shock of the modern surveillance state.
And this brings us to what we could call the modern crisis in perception regarding how we protect this privacy we've built. The source material argues we're moving from a world of vigilance to a world of forbearance.
Okay, unpack those two terms.
Yeah.
Vigilance versus forbearance.
The old system, the property system, Brandeis's system, was about vigilance. You built a fence, you locked your door, you drew the curtains, you took active steps to exclude the world.
You were vigilant.
If you were vigilant, you were private. It was an active process under your control.
But you can't build a fence around your data. You can't put a lock on your email server, not really.
You can't. And this is the shift crystallized in a case called Whalen v. Roe. In that case, New York State was collecting data on patient prescriptions in a central database. There was no physical intrusion. No one broke into a doctor's office.
The data was just collected.
But the court had to recognize a new concept, informational privacy. And this kind of privacy relies on forbearance. We give the state the capacity to know everything. They have the data, they have the servers, but we require them to forbear. We trust them not to look without a very good reason.
That is a terrifying shift in the power dynamic.
It's a total inversion.
Vigilance is in my control. I can buy a better lock for my door. Forbearance is in their control.
Yeah.
I have to hope they follow the rules. I have to trust the systems they build.
And that is why the legal system is struggling so profoundly right now. It is trying to switch from binary reasoning to scalar reasoning.
Okay, binary versus scalar. Go.
Binary is the old way. It's property logic. Is the door open or closed? Is it public or private? It's a switch, on or off.
Simple.
Simple. Scalar reasoning is about degrees. How much intrusion is too much? Think about the Katz case, the phone booth.
Right.
The court famously said you have a reasonable expectation of privacy in a public phone booth. That is a scalar concept. It's not about whether the glass of the phone booth physically prevents sound from escaping physics as it doesn't. It's about whether society expects the government to be listening in on that call. It's a spectrum.
And in a digital world, everything is scalar. If I share my data with a third party, like my bank or a social media app, binary logic says, you shared it. Privacy over. It's public.
Exactly. That's the third-party doctrine, which has caused so many problems. It's a relic of binary thinking. But scalar logic, the logic Heffron and others argue we need, says, wait a minute. Just because I shared this with my doctor or my bank doesn't mean I shared it with the police or with the whole world. I have a degree of privacy. I haven't surrendered everything.
This feels like the current friction point.
Mm-hmm.
The court is trying to run a scalar world on a binary operating system from the 19th century.
And that friction is causing the crisis. The public feels exposed because the old tools of vigilance, like fences, don't work. And the new tools of forbearance, of trust, feel incredibly flimsy. We are waiting for the liquidation of the digital age to happen.
Which leads us directly to the core of our show. We need to integrate this specifically into the crisis in perception.
We do.
Because when we look at the headlines, when we look at the protests outside the Supreme Court, people are arguing about the outcomes. I want this right, or I don't want that right. But they're missing the system that produces those outcomes.
The core misperception here, the crisis, is that the public views privacy rights as one of two things. Either they are judicial inventions, activist judges just making up laws to suit their political agenda,
Which is the conservative critique.
or they are constitutional inevitabilities, magical rights that were always there, hidden in the invisible ink, just waiting for a wise judge to discover them.
Which is often the progressive view. And the reality is neither.
Both are wrong. They miss the point. The obscured layer is the interpretative system itself, that Madisonian framework of developmental supplementation. The system is designed to evolve via liquidation, via a slow, grinding consensus over time. But this mechanism, this deep structure, is totally invisible to the average voter.
We see the verdict, but we don't see the century of shifting social norms that made the verdict inevitable.
Exactly. We get angry about the morality of Griswold. Is contraception good or bad? And we miss the structural precedent of bowling. We miss that the system demands we treat federal and state power symmetrically. We miss the architectural necessity of the decision, regardless of our personal feelings about the outcome.
So surface-level analysis fails because it's case by case. It's emotional. It ignores the institutional constraints. It ignores the system's need for legitimacy and consent.
And when we finally view privacy through a systems lens as developmental supplementation anchored in national practice, the world looks completely different. You no longer see a war between left and right.
What do you see?
You see a feedback loop between social norms, Emerson's individualism, Brandeis's anxiety about new technology, and institutional recognition by the courts.
The crisis really is a failure to perceive the time horizon of the system.
That's it. That is the core of it. We think in election cycles, 2 years, 4 years, maybe 6. The Constitution thinks in generations. It took 100 years to get from property to privacy. It might take another 50 to get from privacy to data sovereignty.
The system is slow by design. It demands that these afterthoughts, these unenumerated rights, become rights only when they achieve the stability of property.
It demands that the new idea becomes as solid, as settled, as taken for granted as the old land. It demands that the software of our rights is as reliable and uncontroversial as the hardware of our houses used to be.
That is a lot to process. But it makes the chaos of the court.
Yeah.
Well, it makes it make a little more sense. It's not just noise. It's a very slow, very heavy machine grinding its way toward a new consensus.
And understanding that machine is the only way to effectively engage with it. If you want to change the output, you can't just yell at the judge. You have to change the consensus. You have to do the generational work of liquidation.
We're going to leave it there for this deep dive.
This project is free and publicly accessible. If you'd like to support the time, tools, and research behind crisis and perception, you can become a supporter on Patreon.
For a shorter visual overview of this topic, see the mini explainer linked in the description.
If you enjoy this kind of systems-level analysis, please like, subscribe, and comment with books or topics you'd like us to explore next.